Welcome back to Dolor Factor Live, of course, only on DBS. You have until 9:30 tonight to send in your answers. Tell us how long Organica has been opened and tell us your favorite Fairy Darren's ice cream. Now, just before we went to the break, I was just blown by what Veronica said about, we were talking about the laws of succession, and if someone died without a will, it was intestate, and if you died with a will, it was testate. And what worried me the most was this intestate, because a lot of our viewers at the moment, you're sitting there thinking, I'm one of those. You need to remain there, sitting there thinking, I've got to do something about it. Veronica, please repeat intestate repercussions, please.
Well, it's very simple. It's just that if you die intestate, you don't leave a will, then the law steps in to take effect. And the law has there's a lot of complications, and it is more so, it's made worse, I think, in St. Lucia, because so many of the children or persons who deceased are illegitimate. So they're children of unmarried parents, and we do not have much protection for illegitimate children. If you are legitimate, yes, you have protection, but even then, well, yes, you have protection. So in a case where the father, you are attempting to inherit from the father, it is made more difficult because of the definition of a single man. You can only inherit from a father if he's defined in law as a single man. Article 579 of the Civil Code, subsection 6 and B says a single man means a man who has never been married. Compare that to a definition of a single woman. It means a single woman includes a widow, a married woman living apart and separated from her husband, and also a divorced woman. So basically, it's easy as a illegitimate child to inherit from your mother, but from your father it's very difficult. And
Why?
Because of the definition in the law of what
Who put that together then?
Well, the law was passed in 1988.
Why hasn't that been challenged?
There is a project that the OECS is undertaking, a family law reform project, and that project was to bring the laws of St. Lucia in line with, if you want to go to the rest of the world, honestly, to ensure that there's non-discrimination against particularly children, family situations, common law situations, and children who are born out of wedlock. I don't think that it has resulted in any legislative changes in certainly in St. Lucia, anything that has passed so far. But in the meantime, that's what we have in our law.
Okay.
So that makes it difficult. And further, in an intestate succession, the law determines what you get and how much of the estate you get. Right? So it's very explicit. It goes on to say, if you are a wife and there are children, then the wife is entitled to a third of the estate, and the children share the others. However, the wife has to be, as we were discussing in the break, capable of inheriting. So the wife can, if there is community property, the wife has to decide whether to keep her half share in the community or give up her community property and share in the third of the entire estate.
But you want to say, first of all, that in the absence of anything to the contrary, she would be entitled to half share. It's just straight community property.
Yes.
Right.
But when you say wife, are we talking about wife who was with you when you passed away, or a strange wife? Let's say you weren't together, but you hadn't divorced. Would that wife still be entitled to that?
Yes. Yes, absolutely.
Yes.
If you are not divorced, you are still legally the spouse of that person. Yes.
Yes.
You can. Now the husband doesn't have to give up his share in the community. Again, the law is very discriminatory in that regard.
The husband doesn't have to give up his share, but the wife does?
But
yes, only the wife.
There is a provision, I believe, that indicates that the husband, if the husband wants to be a spouse capable of inheriting, that husband has to almost like pay in whatever his share of the community into the estate, so to speak, and then he'll be capable of inheriting.
As I say in different strokes, run that by me again.
That's right. It's sort of, to be honest, as far as we are concerned in the law, it's a very difficult provision to really consider how you operationalize
but
it.
I believe the intention had to do with a situation, for example, where you are a wife, you're the spouse, and your share of the community, probably got married, say 2 or 3 years ago, you acquired property in community, your share of the community is negligible, so to speak. However, the husband probably had non-community property prior to the marriage, and his share is that much bigger than if you take your 1/2 share in community. So you'd elect to sort of what they refer to as abandon your interest in that community, your half share of the community, and take the 1/3 share in the bigger estate. I had been thinking about the provision, and I think that's the only logical reason why that provision is there. Because it's an election that you'd have to make as the wife to determine whether or not it is worth my while to go with the 1-share community that comes to me automatically, or go with the give up my rights to the community.
It's a financial decision that the spouse would have to make in terms of what they do, right? But that's something that people don't consider. They don't realize that that is the effect of the law.
You have the option to elect.
Right. And then there are different categories of success. I mean, there is a collateral line and a direct line in terms of who is capable of inheriting from an estate. So if you have if you have no children, then your parents take a share. Your husband or your wife takes a share and they share it with your parents. So the law sets out different degrees and different amounts depending on what it is. The complication comes around when you have situations where, say for example, it is a niece that has been taken care of somebody for many years, and that person has children. They might have gone overseas and didn't do anything for their mother. Those children will inherit and totally exclude that niece. So your participation in the life of somebody doesn't necessarily mean that you are going to be able to inherit from them if that person does not specifically leave a will that says that you are entitled.
That is why the will is so very important.
How do you approach someone to tell them, please do a will, without that person thinking you want something from them? That's why you're asking them to do a will.
Yeah, I think it's a little difficult, and I actually had to deal with that issue not too long ago, where I had a relative who was dying. I could see the relative was dying, and I had the discussion, and you could have seen the reluctance, even indicating whether or not a will even existed. People tend to be a little cagey. Sometimes they have a will, but they would not like to disclose, yes, I have a will. So when the person dies, everybody is at a loss as to whether or not a will even exists. And you have many stories of wills showing up, so to speak, after the person has died.
I think in my experience, once you can explain to the client the importance of the necessity of having a will, when you need to have a little bit more information about the person's own estate, and what are the relationships and whatnot. And if you as an attorney recognize that there are going to be issues, then you ought to indicate very gently to the client, and that is something that you ought to consider. These are the advantages of it, these are the disadvantages of not having it, and whenever you're ready, you're available to do it. Of course, you never force anybody to do something.
And it is a lot easier if the attorney is the one who deals with it instead of the relative, like you were suggesting.
Okay, but here's another way of looking at things. Sometimes people say, oh, there's no point in me leaving a will because I've got nothing to leave. Now, people may think that you may not have money in the bank, but you have other things, don't you? Even if you don't have any money or even land, you may have some namesakes, you may have other things that was handed down to you. Do you think that these things should be included in a will? Andrea?
Absolutely, because otherwise you leave it open to other people coming in and claiming when you might have the desire to have someone else own that property when you pass on.
There's something called in a will, or in terms of succession, a person called a universal legatee. Because the person you leave your property to are your legatees, right? You have heirs, and that person, there's something called a residuary clause in a will, and the person who takes another residuary clause is called a universal legatee. In other words, very simply, it means that if there's any property that at the time of preparing a will you did not know that you were entitled to, you did not know that you have something that came to you after you died, or even before you died, but the will itself did not take it into account, then that person gets it.
It's like a catch-all phrase.
A catch-all phrase, exactly. Okay. And there have been situations where persons become entitled because you might be entitled to somebody else's estate when that person dies. So something that you didn't even think you had, you become entitled to it, and what happens to it then?
And something that happens quite often, in some cases, you might find that someone has a will and gives to, say, the spouse a lifetime interest in the will, in that while the person is alive, the person would be using whatever property. And then when that person passes on, then it comes over to someone else. He might say to my daughter or to my son or wherever it is. And sometimes you're not aware that you have an interest, you know, in that particular property.
Wow.
So sometimes that catch-all phrase, you know, is very useful because it takes care of any eventuality that comes up into the future.
And I think that a lot of people are also kind of worried in terms of the rights of siblings that we are aware of and siblings that we are not aware of. Now, I don't know if this happens in St. Lucia, but I remember in England, lots of surprises coming out on wills, that sometimes for the first time, families are finding out that the person who's died have also left other children that they weren't aware of. And all of a sudden, the will is being shared not by maybe 2 siblings that they knew of, but 4 siblings. Now, in a case like that, can, let's say, his wife and the siblings, the children here, I'm just saying, assuming it's a man who has passed away. In a case like that, can the wife and the 2 children within the family claim that we don't know who these other children are? We are the ones who worked to, you know, make our father's life, you know, substantial. These children had nothing to do with it. They're not having anything in the will. Can that happen?
But it falls back to the law of the jurisdiction as well.
No, in St. Lucia, no. If they are legitimate children, the legitimate children in the case of a man would take with the wife the estate. The illegitimate children are left out completely because he's not a single man. If he is,
it's only in that situation where he's a single man and he dies, that is when the children would inherit.
So okay, I'm saying this in layman's English. So if you are married, you're a legitimate child, your parent passes away, whatever is left to the family you get.
Right.
But if you are an illegitimate child of the father,
right,
you will not get anything.
No. You're not entitled to
You're
anything.
entitled.
No.
Now, what if it's the mother, and the mother has children outside of the marriage, whether it's before or after the marriage? As an illegitimate child, and the mother has passed away, will they be entitled?
Yes, technically yes.
Because it comes back to the definition.
Except that she's a married woman. If she's living with her husband, no. A single woman, married woman living apart and separated from her husband, and also divorced woman. So if she's divorced from her husband or she's living apart from her husband, there is a separation, then yes, as an illegitimate child, you can inherit. But if they're living together and they're in a marriage and whatnot, the husband and the legitimate children will take everything.
Because technically in the situation you just discussed, the woman becomes a single woman.
Yes.
All right. Yeah, I'm breathing. I know that there are many people out there shaking their heads, not believing everything that they're saying, but it's the truth. And that is why, if you haven't made a will, you need to make a will as soon as possible. And if you have made a will that is trillions of years old, perhaps you need to start looking at that now, because life has changed. Things have changed. The people who were around you, they've moved on, or it's changed. You may have more property or less property or whatever. So you need to be looking at that. Now, because indications are already that you have questions, we're actually going to open up the telephone lines earlier than we normally would do, okay? So you've got 10 minutes to answer the questions to win anything tonight. Remember, you can find the questions on dolorfactorlive.com. When we come back, we will take your calls. Now, it's very important because you don't always get an opportunity like this to ask your questions, especially it's free, okay? So give us a call after the break. This is Dolor Factor Live on DBS, and we'll be with you shortly.